Persons and Family Relations Part 2. Marriage under the Family Code of the Philippines. Article 1. Marriage is a special contract of permanent union between a man and a woman entered into in accordance with law for the establishment of conjugal and family life. It is the foundation of the family and an inviolable social institution whose nature, consequences, and incidents are governed by law and not subject to stipulation, except that marriage settlements may fix the property relations during the marriage within the limits provided by this code. Marriage cannot be terminated at will. Nature, incidents and consequences are governed by law and not subject to stipulations except marriage settlements. Case. The validity of a marriage and all its incidents must be determined in accordance with the law in effect at the time of its celebration. In this case, the law in force at the time Leah contracted both marriages was the Civil Code. The children of the parties were also born while the Civil Code was in effect, in this instance in 1979, 1981, and 1985. Hence, the court must resolve this case using the provisions under the Civil Code on void marriages. Essential requisites. Art 2. No marriage shall be valid unless these essential requisites are present, lc. 1. Legal capacity of the contracting parties who must be a male and a female, and 2. Consent freely given in the presence of the solemnizing officer. Legal capacity. Art 5. Any male or female of the age of 18 years or upwards not under any of the impediments mentioned in Articles 37 and 38 may contract marriage. Examples: boy and girl got married and at the time of the marriage girl was 17 years and 11 months old. What is the status of the marriage? Void. It does not matter if only a few days she would be 18. What is important is at the time of the marriage, she is already 18. Can there be a valid marriage between a man and another man? No. Void. Parties must belong to the opposite gender. Exception: Republic versus Kagandahan, intersex individuals. The court, in deciding the case, considered the compassionate calls for recognition of the various degrees of intersex as variations which should not be subject to outright denial. It is of the opinion that sexual development in cases of intersex person makes the gender classification at birth inconclusive. It is at maturity that the gender of such persons, like the respondent, is fixed. Further, the court ruled that in the absence of a law on the matter, it will not dictate on the respondent concerning a matter as innately private as one's sexuality. Respondent is the one who has to live with his intersex anatomy, thus, to him should belong the primordial choice of what courses of action to take along the path of his sexual development and maturation. In the absence of evidence to show that classifying respondent as a male will harm other members of society who are equally entitled to protection under the law, the court affirms as valid and justified the respondent's position and his personal judgment of being a male. Republic v. Kagandahan differentiated from the case of from Republic Silvario, where the court did not grant the petition because there was medical intervention. The sex of a person is determined at birth, visually done by the birth attendant, the physician or midwife, by examining the genitals of the infant. Considering that there is no law legally recognizing sex reassignment, the determination of a person's sex made at the time of his or her birth, if not attended by error, is immutable. Consent must be freely given. Case of Republic versus Albios. Is a marriage contracted for the sole purpose of acquiring American citizenship in consideration of $2,000, void ab initio on the ground of lack of consent. Consent is not invalidated even if the purpose is not to establish family. Consent must be intelligent, parties must know the benefit and consequences. The respondent's marriage is not at all analogous to a marriage in jest. Albios and Fringer had an undeniable intention to be bound in order to create the very bond necessary to allow the respondent to acquire American citizenship. Formal requisites. Article 3. The formal requisites of marriage are: 1. Authority of the solemnizing officer. 2. A valid marriage license except in the cases provided for in Chapter 2 of this title, and 3. A marriage ceremony which takes place with the appearance of the contracting parties before the solemnizing officer and their personal declaration that they take each other as husband and wife in the presence of not less than 2 witnesses of legal age. Solemnizing officer. Persons authorized to solemnize marriage. Art. 7. Marriage may be solemnized by 1. Any incumbent member of the judiciary within the court's jurisdiction. 2. Any priest, rabbi, imam, or minister of any church or religious sect duly authorized by his church or religious sect and registered with the Civil Registrar General XXX. 3. Any ship captain or airplane chief only in the case mentioned in Article 31. 4. Any military commander of a unit to which a chaplain is assigned, in the absence of the latter, during a military operation, likewise only in the cases mentioned in Article 32. 5. Any consul general, consul or vice-consul in the case provided in Article 10. Note that, enumeration not exclusive. Municipal and city mayor may also solemnize under the LGC. Authority of the solemnizing officer, discussion in the ignorance of the law versus mistake of fact. In the ignorance of the law means if the contracting parties go to a person specifically not mentioned by law as having any authority to solemnize a marriage, example notary public, then the marriage is void from beginning even in good faith, a total absence. On the other hand, in mistake of fact, for example, marriage is solemnized by a mayor outside his municipality. Mayor is one of those mentioned by law. Here, good faith is a defense. Valid marriage because of mere irregularity. General rule, those solemnized by any person not authorized to perform marriages are void. Exception, marriage were contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so. An example is a mistake of fact case. An irregularity in any of the formal requisites of marriage does not affect its validity, but the party or parties responsible for the irregularity are civilly, criminally, and administratively liable. Moreover, the solemnizing officer is not duty-bound to investigate whether or not a marriage license has been duly and regularly issued by the local civil registrar. Marriage license. Article 9. A marriage license shall be issued by the local civil registrar, LCR, of the city or municipality where either contracting party habitually resides, except in marriages where no license is required. Exemption from marriage license requirement. 1. In articulo mortis, at the point of death. 2. In remote places, no means of transportation to enable them to personally appear before the LCR. 3. Among Muslims or members of ethnic cultural communities solemnized in accordance with their customs, rights, and practices. 4. Solemnized outside the Philippines, where no marriage license is required by the country where they were solemnized. 5. Ratification by cohabitation, marriage of a man and a woman who have lived together as husband and wife for at least 5 years and without legal impediment to marry each other. Exceptions. Article 27. In case either or both of the contracting parties are at the point of death, the marriage may be solemnized without necessity of a marriage license and shall remain valid even if the ailing party subsequently survives. Article 28. If the residence of either party is so located that there is no means of transportation to enable such party to appear personally before the local civil registrar, the marriage may be solemnized without necessity of a marriage license. Article 33. Marriages among Muslims or among members of the ethnic cultural communities may be performed validly without the necessity of marriage license, provided they are solemnized in accordance with their customs, rights or practices. Article 34. No license shall be necessary for the marriage of a man and a woman who have lived together as husband and wife. 1. For at least 5 years and continuity and exclusivity. 2. Without legal impediment to marry each other. Ratifications by cohabitation. In one case, the Supreme Court held that if the parties falsified the affidavit of cohabitation, it is not mere irregularity in the formal requisite but the total absence thereof. Hence, the marriage is void. Computation of 5-year cohabitation period, computed on the basis of cohabitation as husband and wife where the only missing factor is the marriage contract to validate the union. Exclusivity, no legal impediment was present at any time within the 5 years. Continuity, which means it is unbroken. Marriage ceremony. Art 6. No prescribed form or religious rite for the solemnization of the marriage is required. It shall be necessary, however, for the contracting parties to appear personally before the solemnizing officer and declare in the presence of not less than 2 witnesses of legal age that they take each other as husband and wife. A marriage can be held outside the judge's chambers or courtroom only in the following instances. 1. At the point of death, articulo mortis. 2. In remote places in accordance with Article 29, or 3. Upon the request of both parties in writing in a sworn statement to this effect. There's no prescribed form or formalities, what is required is that there is ceremony. Proxy marriage is void for absence of MC. No 2 witnesses is just a mere irregularity, hence, valid. Mixed marriages and foreign divorce. Lex loci celebrationis. Art. 26. All marriages solemnized outside the Philippines, in accordance with the laws in force in the country where they were solemnized, and valid there as such, shall also be valid in this country, except those prohibited under Articles 35 paragraphs 1, 4, 5, and 6, 36, 37, and 38. Where a marriage between a Filipino citizen and a foreigner is validly celebrated and a divorce is thereafter validly obtained abroad by the alien spouse capacitating him or her to remarry, the Filipino spouse shall have capacity to remarry under Philippine law. Cases. Divorce between Filipinos is void and ineffectual under the nationality rule adopted by Philippine law. The reckoning point is not the citizenship of the parties at the time of the celebration of the marriage, but their citizenship at the time a valid divorce is obtained abroad by the alien spouse capacitating the latter to remarry. In Van Dorn v. Romillo, Jr. we held that owing to the nationality principle embodied in Article 15 of the Civil Code, only Philippine nationals are covered by the policy against absolute divorces, the same being considered contrary to our concept of public policy and morality. Citing this landmark case, the court held in Quita v. CA, that once proven that respondent was no longer a Filipino citizen when he obtained the divorce from petitioner, the ruling in Van Dorn would become applicable and petitioner could very well lose her right to inherit from him. More case laws. In Pilipil v. Ibesomera, we stated that divorce and its legal effects may be recognized in the Philippines insofar as respondent is concerned in view of the nationality principle in our civil law on the status of persons. The divorce decree and the governing personal law of the alien spouse who obtained the divorce must be proven. Our courts do not take judicial notice of foreign laws and judgments, hence, like any other facts, both the divorce decree and the national law of the alien must be alleged and proven according to our law on evidence. A recognition of a foreign judgment is not an action to nullify a marriage. It is an action for Philippine courts to recognize the effectivity of a foreign judgment, which presupposes a case which was already tried and decided under foreign law. In this jurisdiction, the following rules exist. 1. Philippine law does not provide for absolute divorce, hence, our courts cannot grant it. 2. Consistent with Articles 15 and 17, the marital bond between 2 Filipinos cannot be dissolved even by an absolute divorce obtained abroad. 3. An absolute divorce obtained abroad by a couple, who are both aliens, may be recognized in the Philippines, provided it is consistent with their respective national laws. 4. In mixed marriages involving a Filipino and a foreigner, the former is allowed to contract a subsequent marriage in case the absolute divorce is validly obtained abroad by the alien spouse capacitating him or her to remarry. Based on a clear and plain reading of paragraph 2 of Article 26, it only requires that there be a divorce validly obtained abroad. The letter of the law does not demand that the alien spouse should be the one who initiated the proceeding wherein the divorce decree was granted. It does not distinguish whether the Filipino spouse is the petitioner or the respondent in the foreign divorce proceeding. Pursuant to Manalo, foreign divorce decrees obtained to nullify marriages between a Filipino and an alien citizen may already be recognized in this jurisdiction, regardless of who between the spouses initiated the divorce, provided, of course, that the party petitioning for the recognition of such foreign divorce decree, presumably the Filipino citizen, must prove the divorce as a fact and demonstrate its conformity to the foreign law allowing it. Void marriages. Void marriages differentiated from voidable marriages. In void marriage, the marriage is inexistent from the beginning, while in voidable it is valid until annulled. The property relations in void marriages governed by the rule on co-ownership. If capacitated, Art. 147 applies. If there is an impediment, 148 applies. In voidable, it is governed by marriage settlement or in the absence thereof by absolute community property until termination. The status of the children born in void marriages are illegitimate unless void marriage falls under Art. 36 and 53. While in voidable, they are legitimate if conceived prior to the finality of decree of annulment. Void marriages cannot be ratified while in voidable may be validated by free cohabitation or prescription. The period to assail in void marriages is any time even after death of the party. The nullity may be raised by way of action or defense, subject to the rule that the direct petition to declare a marriage void may only be filed by the husband or the wife. On the other hand, in voidable marriages, it should be assailed within 5 years depending on the ground. Art. 35. The following marriages shall be void from the beginning. 1. Those contracted by any party below 18 years of age even with the consent of parents or guardians. 2. Those solemnized by any person not legally authorized to perform marriages unless such marriages were contracted with either or both parties, believing in good faith that the solemnizing officer had the legal authority to do so. 3. Those solemnized without license, except those covered the preceding chapter. For those bigamous or polygamous marriages not failing under Article 41. 5. Those contracted through mistake of one contracting party as to the identity of the other, and 6. Those subsequent marriages that are void under Article 53. No partition or distribution in the first marriage. Article 36. Psychological incapacity. Art. 36. A marriage contracted by any party who, at the time of the celebration, was psychologically incapacitated to comply with the essential marital obligations of marriage, shall likewise be void even if such incapacity becomes manifest only after its solemnization. Meaning, psychological incapacity should refer to no less than a mental, not physical, incapacity that causes a party to be truly incognitive of the basic marital covenants that concomitantly must be assumed and discharged by the parties to the marriage which, as so expressed by Article 68 of the Family Code, include their mutual obligations to live together, observe love, respect and fidelity and render help and support. Requisites. Psychological incapacity must be characterized by a. Gravity. The incapacity must be grave or serious such that the party would be incapable of carrying out the ordinary duties required in marriage. b. Juridical antecedents. It must be rooted in the history of the party antedating the marriage, although the overt manifestations may emerge only after the marriage, and c. Incurability. It must be incurable or, even if it were otherwise, the cure would be beyond the means of the party involved. Santos v. C.A. Case Laws. Chiming Tsoy v. C.A. One of the essential marital obligations under the Family Code is to procreate children based on the universal principle that procreation of children through sexual cooperation is the basic end of marriage. Constant non-fulfillment of this obligation will finally destroy the integrity or wholeness of the marriage. In the case at bar, the senseless and protracted refusal of one of the parties to fulfill the above marital obligation is equivalent to psychological incapacity. Tanandol vs. Andol 2021. Psychological incapacity is neither a mental incapacity nor a personality disorder that must be proven through expert opinion. There must be proof, however, of the durable or enduring aspects of a person's personality, called personality structure, which manifests itself through clear acts of dysfunctionality that undermines the family. The spouse's personality structure must make it impossible for him or her to understand and, more important, to comply with his or her essential marital obligations. Psychological incapacity is not a medical but a legal concept. It refers in relation to a specific partner that may exist at the time of the marriage but may have revealed through behavior subsequent to the ceremonies. It need not be a mental or personality disorder. It need not be a permanent and incurable condition. Therefore, the testimony of psychologist or psychiatrist is not mandatory in all cases. The totality of the evidence must show clear and convincing evidence to cause the declaration of nullity of marriage. Incestuous marriage. Art. 37. Marriages between the following are incestuous and void from the beginning, whether relationship between the parties be legitimate or illegitimate. 1. Between ascendants and descendants of any degree, and 2. Between brothers and sisters, whether of the full or half-blood. Art. 38. The following marriages shall be void from the beginning for reasons of public policy. 1. Between collateral blood relatives, whether legitimate or illegitimate, up to the 4th civil degree. 2. Between step-parents and step-children. 3. Between parents-in-law and children-in-law. 4. Between the adopting parent and the adopted child. 5. Between the surviving spouse of the adopting parent and the adopted child. 6. Between the surviving spouse of the adopted child and the adopter. 7. Between an adopted child and a legitimate child of the adopter. 8. Between adopted children of the same adopter, and 9. Between parties where one, with the intention to marry the other, killed that other person's spouse, or his or her own spouse. Note that marriage between the surviving spouse of the adopter and surviving spouse of the adopted is not prohibited. The adopted can marry the illegitimate child of the adopter. The adopted can also marry the parents and all relatives by affinity or consanguinity of the adopter. Article 40 and the crime of bigamy. Art. 40. The absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. For a person to be convicted of bigamy, the following elements must concur. 1. That the offender has been legally married. 2. That the first marriage has not been legally dissolved or, in case of an absentee spouse, the absent spouse could not yet be presumed dead according to the provisions of the Civil Code. 3. That the offender contracts a second or subsequent marriage, and 4. That the second or subsequent marriage has all the essential requisites for validity. In the case of Pulido v. People, the doctrine is: a judicial declaration of nullity of a previous marriage is necessary before a subsequent one can be legally contracted. Facts of the case: the marriage between petitioner Susan Nickdow and the deceased, having been solemnized without the necessary marriage license, and not being one of the marriages exempt from the marriage license requirement, is undoubtedly void ab initio. Accordingly, the declaration in the instant case of nullity of the previous marriage of the deceased and Susan Nickdow does not validate the second marriage of the deceased with Susan Yee. The fact remains that their marriage was solemnized without first obtaining a judicial decree declaring the marriage of Susan Nickdow and the deceased void. Hence, the marriage of Susan Yee and the deceased is, likewise, void ab initio. Whether or not the RTC erred in quashing the information for bigamy filed against respondent. Yes. Here, at the time respondent contracted the second marriage, the first marriage was still subsisting as it had not yet been legally dissolved. In Atienza v. Brillantes, Jr., the court already made the declaration that Article 40, which is a rule of procedure, should be applied retroactively. Art. 40 of the Family Code did not amend Art. 349 RPC and should not be construed in a way that to deny the accused the right to collaterally attack a void marriage in a criminal prosecution for bigamy. Reappearance of the spouse. Art. 41. A marriage contracted by any person during subsistence of a previous marriage shall be null and void, unless before the celebration of the subsequent marriage, the prior spouse had been absent for 4 consecutive years and the spouse present has a well-founded belief that the absent spouse was already dead. In case of disappearance where there is danger of death under the circumstances set forth in the provisions of Article 391 of the Civil Code, an absence of only 2 years shall be sufficient. For the purpose of contracting the subsequent marriage under the preceding paragraph, the spouse present must institute a summary proceeding as provided in this code for the declaration of presumptive death of the absentee, without prejudice to the effect of reappearance of the absent spouse. What are the conditions? 1. Absence of the other spouse must have been for 4 consecutive years, or 2 years under exceptional circumstances. 2. Well-founded belief of the present spouse who wishes to marry that absent spouse is already dead. 3. Judicial declaration of presumptive death. A present spouse must file a summary proceeding for the declaration of the presumptive death of the absentee without prejudice to the latter's reappearance. Case law. Mere reappearance will not terminate the subsequent marriage even if the parties were notified of the reappearance. If no step was taken to terminate the subsequent marriage either by filing an affidavit of reappearance or by a court action. Since the second marriage has been contracted because of a presumption that the former spouse is dead, such presumption continues in spite of the spouse's physical reappearance and by fiction of law, he or she must still be regarded as legally an absentee until the subsequent marriage is terminated in the manner provided by law. Recording of reappearance, terminate subsequent marriage. Children born prior to the termination of subsequent marriage are still legitimate. Grounds for annulment of marriage, Article 45. Lack of parental consent. Unsoundness of mind. Consent obtained by fraud. Consent obtained by force, violence, intimidation, or undue influence. Physical incapacity of consummating the marriage. As opposed to inability to procreate or sterility, which is not a ground for annulment of marriage. Afflicted with sexually transmitted disease that is serious and incurable. Art 46. Any of the following circumstances shall constitute fraud referred to in number 3 of the preceding article. 1. Non-disclosure of a previous conviction by final judgment of the other party of a crime involving moral turpitude. 2. Concealment by the wife of the fact that at the time of the marriage, she was pregnant by a man other than her husband. 3. Concealment of STD, regardless of its nature, existing at the time of the marriage, or 4. Concealment of drug addiction, habitual alcoholism or homosexuality or lesbianism existing at the time of the marriage. Note, even if the sexually transmissible disease is later on cured, the marriage can still be annulled. It's the concealment at the time of the marriage that would vitiate the consent of the other spouse. Case of fraud. Concealment by the wife of the fact that at the time of the marriage, she was pregnant by a man other than her husband constitutes fraud and is ground for annulment of marriage. One can hardly seek for annulment on the ground of concealment of pregnancy where the woman at the time of the celebration of marriage is in an advanced state of the pregnancy or at 7 months. Court refused to set aside the marriage. Art 47. The action for annulment of marriage must be filed by the following persons and within the periods indicated herein. 1. For causes mentioned in number 1 of Article 45 by the party whose parent or guardian did not give his or her consent within 5 years after attaining the age of 21, or by the parent or guardian or person having legal charge of the minor at any time before such party has reached the age of 21. 2. For causes mentioned in number 2 of Article 45, by the same spouse who had no knowledge of the other's insanity, or by any relative or guardian or person having legal charge of the insane, at any time before the death of either party, or by the insane spouse during a lucid interval or after regaining sanity. 3. For causes mentioned in number 3 of Articles 45, by the injured party, within 5 years after the discovery of the fraud. 4. For causes mentioned in number 4 of Article 45, by the injured party, within 5 years from the time the force, intimidation or undue influence disappeared or ceased. 5. For causes mentioned in number 5 and 6 of Article 45, by the injured party, physical incapacity and STD, within 5 years after the marriage. Effect of defective marriages. Art 50. The effects provided for by paragraphs 2, 3, 4, and 5 of Article 43 and by Article 44 shall also apply in the proper cases to marriages which are declared ab initio or annulled by final judgment under Articles 40 and 45. The final judgment in such cases shall provide for the liquidation, partition, and distribution of the properties of the spouses, the custody and support of the common children, and the delivery of third presumptive legitimes. Art 55. A petition for legal separation may be led on any of the following grounds. 1. Repeated physical violence or grossly abusive conduct directed against the petitioner, a common child, or a child of the petitioner. Note: violence need not be physical. It is submitted that psychological and sexual violence and repeated verbal abuse may qualify as grossly abusive conduct. 2. Physical violence or moral pressure to compel the petitioner to change religious or political affiliation. 3. Attempt of respondent to corrupt or induce the petitioner, a common child, or a child of the petitioner, to engage in prostitution, or connivance in such corruption or inducement. Note: mere attempt is sufficient. 4. Final judgment sentencing the respondent to imprisonment of more than 6 years, even if pardoned. Note: must be final judgment. 5. Drug addiction or habitual alcoholism of the respondent. Note: suppose H at the time of the marriage with W was already an alcoholic but concealed it to W. What is the remedy of W? May ask for annulment on the ground of fraud, as long as there is concealment. If no concealment and arose only after marriage, legal separation is the remedy. 6. Lesbianism or homosexuality of the respondent. Note: if with concealment, party may file for annulment. 7. Contracting by the respondent of a subsequent bigamous marriage, whether in the Philippines or abroad. 8. Sexual infidelity or perversion. 9. Attempt by the respondent against the life of the petitioner, or defense if purely accident equals not a ground for legal separation. 10. Abandonment of petitioner by respondent without justifiable cause for more than 1 year. For purposes of this article, the term child shall include a child by nature or by adoption. Case: a decree of legal separation, on the ground of concubinage, may be issued upon proof by preponderance of evidence in the action for legal separation. No criminal proceeding or conviction is necessary. If there is legal separation, can the spouses remarry? No, because the marriage, vinculum or tie, is not dissolved. It would be a case of bigamy. Defenses for legal separation. Art 56. The petition for legal separation shall be denied on any of the following grounds. 1. Where the aggrieved party has condoned the offense or act complained of. 2. Where the aggrieved party has consented to the commission of the offense or act complained of. 3. Where there is connivance between the parties in the commission of the offense or act constituting the ground for legal separation. 4. Where both parties have given ground for legal separation. 5. Where there is collusion between the parties to obtain decree of legal separation, or 6. Where the action is barred by prescription. First defense: condonation. Condonation is the conditional forgiveness or remission by a husband or wife of a matrimonial offense which the latter has committed. A single voluntary act of sexual intercourse by the innocent spouse after discovery of the offense is ordinarily sufficient to constitute condonation, especially as against the husband. Where the parties live in the same house, it is presumed that they live on terms of matrimonial cohabitation. Case: there has been a condonation by the defendant of the acts committed by the wife because the defendant had given money to the plaintiff on several occasions through third persons. Pardon or condonation does not require sexual intercourse and it may be express or implied. 2. Consent. Case: the husband consented to the adulterous relations existing between the accused and therefore he is not authorized by law to institute this criminal proceeding. While the agreement is void in law, this will constitute as a defense for legal separation. 3. Connivance. The furtive consent of one person to cooperate with another in the commission of an unlawful act. The tacit encouragement of or assent to another's wrongdoing. An agreement or consent, indirectly given, that something unlawful shall be done by another. 4. Recrimination or mutual guilt. Case. While there is a conceptual difference between consent and pardon in the sense that consent is granted prior to the adulterous act while pardon is given after the illicit affair, nevertheless, for either consent or pardon to benefit the accused, it must be given prior to the ling of a criminal complaint. 5. Collusion. In divorce, nullity and annulment, or legal separation means the agreement between husband and wife for one of them to commit, or to appear to commit, or to be represented in court as having committed a matrimonial offense, or to suppress evidence of a valid defense, for the purpose of enabling the other to obtain a divorce. This agreement, if not express, may be implied from the acts of the parties. It is a ground for denying the divorce. 6. Prescription. Art. 57. An action for legal separation shall be filed within 5 years from the time of the occurrence of the cause. Note, not from the time of discovery. Death of the spouse extinguishes the ground for legal separation. Reason, the principal purpose of legal separation is to separate the spouses from bed and board. Separation of properties is merely incidental. If one of the parties died, there can be no permanent separation than death. Therefore, there is no longer need to pursue for legal separation. Personal actions die with the person. Procedure for legal separation. 1. No hearing within 6 months from filing, cooling off period. Note, in VAWC, 6 months cooling off does not apply if there is an allegation of violence. 2. No decree can be issued without efforts towards conciliation. 3. No decree based on stipulation of facts or confession of judgment. 4. Court should order fiscal to take steps to prevent collusion. X. 1. After filing, the spouses may live separately. 2. During pendency of the action, the court may provide order of support and custody of children in accordance with Article 49 of the Family Code. 3. Absolute community or conjugal partnership is dissolved and the guilty spouse is not entitled to a share in the profit. 4. Offending spouse is disqualified to inherit from the innocent spouse. 5. Innocent spouse may revoke donation in favor of guilty spouse. Reconciliation. There should be joint manifestation under oath of reconciliation to be filed in court. Consequences of reconciliation. Art. 66. The reconciliation shall have the following consequences. 1. The legal separation proceedings, if still pending, shall thereby be terminated at whatever stage, and 2. The final decree of legal separation shall be set aside, but the separation of property and any forfeiture of the share of the guilty spouse already effected shall subsist, unless the spouses agree to revive their former property regime. Agreement to revive former property regime must also be under oath. That's all for marriage under the Family Code. Next part is property relations under the Family Code and Civil Code of the Philippines. Thank you.